Tonight, we'll take a look at the legal implication of the latest court order by a Rivers State High Court, which declared Martin Amaewhuke-led 27 lawmakers of the Rivers State House of Assembly as legitimate members of the People's Democratic Party. The court, in a ruling on Monday, struck out a suit filed by Wosa Amadi and 3 others seeking to declare the seats of the 27 lawmakers vacant following their defection to the All Progressives Congress in December 2023. Now let's speak with Liborous Oshoma, a lawyer and public affairs analyst. Good evening to you, Mr. Oshoma. Thank you so much for joining us this evening. Thank you.
Yeah, good evening. Thank you.
All right. I mean, in the last 24 hours, we've heard several angles. Legal luminaries have been speaking, ordinary Nigerians have been speaking. But there are those who have said it's important for us to look at this issue from 2 different perspectives. The premise of law and on the premise of equity. I wonder how that will happen, but we'll find out tonight. So first, what do you make of this recent court judgment? How do you assess this judgment? Is the coast now clear for the Rivers 27 lawmakers to continue the business of lawmaking?
Sorry, I didn't get your question. Sorry, I had an interference. I didn't get
all right.
your...
So can you hear me, Mr. Oshoma? Can you hear me? So let me repeat that question. How do you assess this recent judgment? And is the coast now clear for the 27 lawmakers to return or to begin the business of lawmaking again?
Yeah, basically, what the court had said is very simple. It's very easy to understand that resignation, it's not a newspaper thing or a television thing, and that there are procedures for resigning from any political party or from any office, and that so resignation, there are letters of resignation from political parties, and there are also letters of joining another political party and the register of that political party, and that's the only way that you can establish the membership of a political party, and that's so. In the absence of a resignation letter from a political party, that you can't say that somebody has resigned from that party. It now becomes a mere conjecture or rumor in the absence of a letter. Somebody can say, well, I've resigned from your party. And then once there is no letter to show that he actually resigned, he can say, well, it was just a mere word, that there is no letter. You remember, if you remember, I think it was Adamawa State now. Adamawa State, during the time of, in Yako. In Yako, there was the governor, I've forgotten his name now, the governor, yes, Murtala Yako was impeached, and there was a governor, the deputy governor of Adamawa State. There was an allegation that he resigned his seat, and that issue of resignation came up, and the provisions of the Constitution, was clear. And once a resignation letter takes effect, the moment it is received to whom it is addressed to. And the question was, who should a resignation letter be addressed to? It's a resignation letter from a governor addressed to the president. Can you say a governor has truly resigned when a resignation letter is addressed to the president or addressed to a political party? And it was a unanimous decision of the Supreme Court then that a resignation letter ought to be addressed to the Speaker of the House. And that is the provisions of the law. And so, in the absence of a resignation letter addressed to the Speaker of the House, that there you cannot say there was indeed a resignation. So, and that was what saved the governor of Adamawa State then. And so I think what basically this court have done is to follow that laid down decision of the Supreme Court in that matter to say that yes, you can, somebody can be alleged to have resigned on the pages of newspaper or on television, but in the absence of a resignation letter, or in the absence of a register of political party showing his registration in that political party, it is difficult to say that that person had, defected or joined another political party. So it now introduced a new interpretation, a technical interpretation to the issue of cross carpet. Before, I think what really happened was members who announced their defection on the floor of the House, that as a result of, whether crisis or whatever had happened in their party, and that they have resigned their membership of the party. I remember Senator Danjuma Goje then, when I think about 11 senators defected from the then PDP to the APC. I also remember when Aminu Tambuwa announced his resignation or his defection from the then PDP to APC. But all of this, even though those resignation or defection were announced on the floor of the House, but the issue that the court has dealt with now is that they were also supported by letters addressed to the ward chairman of those political parties. So in the absence of those letters, which is a technical issue though, then that you cannot say such persons have actually resigned or defected.
What happens with the existing interlocutory injunction that Amaewhuke and others should not parade themselves as members of the State Assembly? Does this really counter that existing injunction?
This is a final judgment of the court and not an interlocutory. Interlocutory, let me distinguish it here. There's what we call interim, interlocutory, and perpetual injunction. A lot of people mistake these things. Interim is usually given before hearing both parties. And if there is need to sustain that order given interim, after hearing both parties, and for the court to be able to determine, or for a fait accompli not to be posted on the court will usually give an interlocutory injunction pending the hearing and determination of the substantive suits. The interlocutory injunction is usually to sustain the rest pending the determination of the final suit. And so, it is after a final suit has been determined that the court now says, well, we've granted a perpetual injunction if there is really need to restrain such persons. But in this case, the court has said, well, we do not see, looking at the gamut of documents submitted before us, there is no document here showing that these members have actually, resigned from PDP. There is no document or register showing in APC that they've actually, joined a political party, the APC as a political party. Their names are not on the register of political parties of the APC. It has not been shown before the court, at least the court worked with evidence, and that also there are no documents supporting the originating process to show that truly there was indeed resignation. So this is a judgment on its own, and so you cannot, it's like placing an interlocutory application before a final judgment. That does not work.
State Attorney General. And with what we have in Section 272, subsection 3, does this mean that both justices did not have jurisdiction to hear this case in the first place? I mean, some persons had said they would have expected the court to dismiss the suit.
You see, the question here really is the fact that on the issue, what was the issue submitted before the court? The issue that was submitted before the courts are issues bordering on, enforcement of fundamental rights. And if a matter is submitted for enforcement of fundamental rights and the court is determining that matter, now had to determine the issues of resignation of members, then the courts, you can't ask the court to throw away such a matter because the court is not discussing, or the court is not seized of the fact of issues that had to do with determining the, solely, the court is not determining the tenure of members, which is entirely within the purview of the Federal High Court to deal with. The matter that was submitted before that court is a matter for enforcement of fundamental rights. And in enforcing fundamental rights, has this right been breached? And what is leading to the breach? And so, can these members, because the fact was that I think the applicants approached the court and held for court to determine if those people who are still parading themselves as member, if the act itself has breached the fundamental right of the applicant. And so the court determining whether a right had been breached now had to look into whether those people are members. I think it's a bit technical. People would really understand it, because you know what lawyers do? When they know that the court is robbed of jurisdiction of a matter, they hide under, you look for something that will cloak the court with jurisdiction. Let me quickly give you an instance. Take, for example, the National Industrial Court is seized with matters that have to do with contract of employment, dismissal. But if in the course of an employment, somebody is libeled or somebody is defamed, and so in determining that employment within the industrial court, that issue of defamation also can be brought up, and so the court will be seized of the fact to determine the issue of defamation and libel, even though it is not entirely within the purview of that court to so do. So I think that's what they have done here, brought the issue of the question of enforcement of fundamental rights, which the State High Court has jurisdiction to deal with. And in dealing with that, now had to determine a question on whether these people who are threatening to breach the right that is being, protected, whether they have the power to parade themselves as members of the State House of Assembly.
All right, Mr. Liborous, let me rephrase that question for the purpose of clarity and for the purpose of those who are not lawyers like myself. Now, in this case, neither of the parties canvassed the issue of jurisdiction before now. So are you saying that a court can admit a case even if it is outside its jurisdiction?
No, that's not what I'm saying.
Okay.
That's not what I'm saying. What I'm saying is, if the court is not cloaked with jurisdiction, the court suo motu, like we say, the court on its own can look at the matter and say, well, I do not have jurisdiction to determine this matter, whether the parties canvass jurisdiction or not. But the question is, the issue that was submitted before the court, does the court have powers to deal with that issue that was submitted before it? Yes, the court has the powers to deal with the issue of enforcement of fundamental rights. And in dealing with the issues of enforcement of fundamental rights, what are the ancillary issues that came up? The ancillary issues that came up were the issues of whether the members or the people who are threatening this right that is about to be enforced, whether they are members of the State House of Assembly. So, and the court looked at all of the issues. That was why I gave you an example with defamation and the contract of employment. Ordinarily, if it is defamation suo motu, if it is defamation strictly speaking, then the industrial court would not have the jurisdiction to entertain the matter. If it is the issues to be determined are solely questions of the tenure of members, then the State High Court will tell you that they have no jurisdiction. But the issues submitted before the State High Court were the determining the question of enforcement of fundamental rights. Somebody who feels his right is about to be breached by virtue of Section 41 of the Constitution can approach the court. 46 of the Constitution can approach the court for the protection of that right. And in approaching the court, you can approach the Federal High Court or the State High Court. And the applicant approach the Federal High Court or the State High Court. And the court is looking at those rights first and foremost. What is your right? What is your locus? Do you have a cause of action? Do you have a right of action? And in determining that right of action, who are those parties that are about to breach your right? Oh, these members are parading themselves as members of the State House of Assembly. So, if I have been elected as Speaker and these people are claiming that they are members, but in the recent, and I feel that position as a duly elected Speaker, and the court says, well, from the documents submitted before me, I do not see from the documents submitted before me, I do not see any resignation here to claim that those rights, your right is about to be breached or is about to be threatened.
All right. I mean, so earlier you said this order introduces a new interpretation to matters of defection and cross-carpeting. So does this mean that we need a higher court to give us a clearer understanding or a better understanding of what constitutes membership of a political party, given the circumstances of this particular case? And do you also think that we need a higher court to now lay bare what constitutes crisis in a political party and whether or not this must trickle down from the national level?
No. I think it is only here that once a court gives an order, we'll all be waiting until the Supreme Court makes a pronouncement on it before we believe that the law has been pronounced. The law is what the court says it is. The Supreme Court had determined in pectoral of authority what constitutes a crisis in a political party. And the Supreme Court had held in all of those cases that a crisis at the local government level or a crisis at the state level is not the crisis envisaged by the provisions of the Constitution, that a crisis in the political party at the national level to the extent that you can see that indeed there is a crisis and you have one, what do you call it, one part of the political party here and the other part of the political party there. So that's what the Supreme Court, has interpreted to amount to a crisis. And so that also laid to rest the attitude of politicians where they orchestrate crisis in a party to give them opportunity to defect. So that said, this court is not looking into what amounts to crisis or whether there's a crisis or not, or what whether parties have, or whether there's a crisis in the party that led to defection. No, that's not what the court is looking at. What the court simply looked at is determination of fundamental rights. And in determining the fundamental rights, how do you, if you now say some members have resigned or have defected from a political party, and the court says for a party to defect, for a party to resign from a political party, those resignation letters must be shown, must be exhibited for a court to make a pronouncement that truly, indeed, members have resigned from that party. That's what resignation is all about. If you say, and that's why I brought the case of, is it Fintiri now, in Adamawa State. And so that for you to say a governor has been resigned, it is not that a resignation letter will just show, but that resignation letter was indeed addressed to the person who is authorized to receive the resignation letter, and it was indeed received, whether acted upon or not. That a resignation letter emanated and was addressed to somebody who ought to make a pronouncement on it. I think that was in 2011 or so. So, in this case, the court is also saying there is no resignation letter at all. That there is none at all. Even if there is none exhibited before the court. For you to now say that these people are not members of the political party and they are about to threaten your right.
All right, but what do you think is the interest of the PDP that has sought to be joined in this matter?
I think, the PDP, it's a house divided against itself. We cannot pretend that PDP seriously polarized today. Unfortunately, after the 2015 election, the PDP became so rudderless that they were looking for a leader. And they sold their political party to some persons. I think Wike bought some. And so we also saw how courts were granting orders in Abuja and in Port Harcourt. And to a very large extent, Wike, except we want to deceive ourselves, Wike became a very strong financial of PDP. And still that, consistently has shown in the affairs of the PDP. And so in this politics of Rivers State, Wike is at the center. Nobody would deny that fact. And you saw the last, was it emergency meeting that the PDP had? A lot of people thought that the Wike's hold on the party, that was the end of Wike's hold on the party. But unfortunately, that didn't happen. His leadership that he put in place, a vote of confidence was passed on it, and everybody went back home. So I think what the PDP basically is trying to do, like they say, he who pays the piper, they take the tune. So we can't run away from the fact that what you see playing out here is the leadership of the party trying to also support one of their own, because the politics of Rivers State is at play. And the politics of Rivers State, the PDP had benefited from it, immensely. And I think what they are just trying to do here is to support the fact that indeed none of them has received resignation letter of the police of the alleged resigned 27 law. So we already know where the PDP national, is facing in the matter. So that's why they're so much interested in joining the party. And also, APC might also come in also and say, well, these people have not joined us. I think APC also issued a press statement claiming that the members didn't join their party. So
that's correct.
It's an interesting time ahead, and so I think they will also want to join to come, need evidence to say that
absolutely
these people did not join their party.
I mean, we'll see how all of this unfolds in the coming days. Thank you so much for joining us this evening. I've been speaking with Liborous Oshoma, a lawyer and political affairs analyst. Thank you so much for always coming to our aid. I mean, especially when we're very confused about some of those legal matters. Thank you so much for joining us again.
Yeah, my pleasure. My pleasure. I'm sorry for the interruption. It was a Nigerian situation.
It's fine. Thank you so much.